For the past 8 years, the All Kenyan Moot Court competition has been keen on pushing the conversation on human rights within the Kenyan context. Through conducting various Moot Court competitions centered around human rights issues happening in Kenya, we've been able to engage with various stakeholders and, most importantly, law students from across the various universities countrywide to steer human rights discussions among students. This year will not be any different. Even with the COVID-19 pandemic that has changed what would be the old order to what is the new normal, we will hold our conference and Moot Court competitions to push the conversation around health and corruption. With a key focus on the Article 43 right, its realization, government response to the COVID-19 pandemic, and the malignant cancer of corruption that has over the years crippled the Kenyan healthcare sector. Join us virtually from the 2nd to the 5th of June 2021 as we discuss the theme, Combating Corruption in the Attainment of the Highest Attainable Standard of Health. All are welcome.
Good morning, good afternoon, and good evening from wherever you're watching us from. Welcome to the All Kenyan Moot Court competition, the final rounds. My name is Susan Maina and I shall be your bailiff. And I would like to confirm that all the participants and the judges are with us. And at this moment, I would like to hand over to the presiding judge, that is Judge Bush. So Judge Bush, are you here with us?
Well, good afternoon everyone. The bench welcomes teams 909 and 708 to the hearing of the constitutional petition number 17 of 2021 between our Human Rights Commission, the petitioner, and the Attorney General and the Cabinet Secretary for Health being the respondents. My name is Mr. Bush Wanjala, the presiding judge. I will ask my fellow judges to introduce themselves before we proceed.
Thank you, presiding judge. My name is Isabella Obara, and I welcome all the teams to this particular hearing, and I wish you all the very best. Thank you.
Good afternoon once again. My name is Dennis Moroga, and I wish you all the best. Thank you.
Good afternoon, everyone. My name is Nerima Were, and congratulations for getting so far, and wish you the best for this afternoon.
Thank you very much. So to the participants, do you students of team code 909 appearing on before this bench solemnly promise that you will abide by the rules of the virtual oral pleading of the All Kenya Moot Court competition, and that you will not communicate with or accept assistance from in any way your coaches or other individuals during the oral pleading?
Your Honor, we do.
Yes, we do.
Do you, the students of team code 708 appearing on before this bench solemnly promise that you will abide by the rules of the virtual oral pleading of the All Kenya Moot Court competition, and that you will not communicate with or accept assistance from in any way your coaches or other individuals during the oral pleading?
Yes, I do.
Yes, we do.
I would just like to remind all the participants that failure to comply with the rules or accept your acceptance of help from outside sources, including coaches, may result in the bench recommending your disqualification to the steering committee. I hope you will take that note. In that regard, we will begin with the petitioner. I would like you to introduce yourselves and give a brief on what you will be presenting to the judges today.
Good afternoon, bench. My name is Counsel Marian B. Chepkemoi. Together with co-counsel Lois Morora, we appear on behalf of the petitioner in the matter between Nauru Human Rights Commission versus the Attorney General and the Cabinet Secretary for Health, Republic of Struggle. We shall both take 15 minutes of the court's time to address the court on both procedural and substantive aspects of this case. For clarity, I shall address the court on the procedural matters as well as the first and second substantive issues. after which my co-counsel shall address the court on the third and fourth substantive issues, as well as submitting on our prayers. It is a pleasure to appear before you today. We are ready to begin.
Thank you. I would also like to request the respondents to introduce themselves and briefly and let us know what we'll be expecting to hear from you today.
My lords and my ladies, and may it please this honorable court, my name is Kome Jaden from Team 708, and my co-counsel in this matter is Ms. Tori Kobonyo. We appear on behalf of the respondent in this matter, and we intend to take the next 30 minutes to make our submissions. I shall take the first 15 minutes to address this honorable court on the issues of jurisdiction and locus standi, followed by the first issue under which the government has upheld the right to the highest attainable standard of health and the right to emergency medical treatment of the citizens of Tunastrago. And the second issue under which the government has not violated the right to industrial action, the right to fair administrative action, and the right to work of the striking healthcare workers. Additionally, my co-counsel shall take the remaining 15 minutes to make her submissions on the third issue under which the government was not involved in the extrajudicial killings and enforced disappearance of the 4 people. And the fourth issue under which the government has upheld all of its obligations with regards to the fight against corruption. We are very pleased to appear before this court today and are hoping to make fruitful submissions.
Thank you very much for that. Back to the petitioners. You may begin, noting that you have 30 minutes to present your case.
Thank you. On the procedural aspects, the petitioner submits that this court has jurisdiction, that all matters brought before this court are admissible, and that the petitioner in the matter has locus before the court. Your Honor, this court has jurisdiction pursuant to Article 165.3 of the Constitution, read together with 165.3d subarticle Roman 3, which both provide as follows. That 1, this court has jurisdiction on matters denial, infringement, and violation of any rights contained in the Bill of Rights. It is clearly stated that this court has jurisdiction on any matter relating to a power granted by the Constitution to a state organ. Your Honors, Issue 4 contains a matter that relates to powers that have been granted to a state organ. Therefore, Your Honor, this court has the requisite jurisdiction to handle this matter. Hence, all matters brought before this court are admissible. Your Honor, on locus standi, the petitioner submits that the petitioner in this matter has locus pursuant to Article 22 of the Constitution, read together with Article 258 of the Constitution of Tunastrago, which both provide that any person can institute proceedings before court alleging violation of a right or alleging a breach of a constitution. Your Honor, the matters brought before this court are matters of the breach of the Constitution, and pursuant to Article 22, Nauru Human Rights Commission represents the families of the victims of the violations of the contained in the Bill of Rights, as well as the Health Workers Union. It is therefore a submission that this court has jurisdiction and that the petitioner in this matter has locus, and therefore all matters brought before this court are admissible.
Counsel, before you proceed,
yes, Your Honor.
Is it your view that the courts established under Article 162.2 cannot hear matters pertaining to breaches of the human rights or Bill of Rights under the Constitution?
No, Your Honor. It is our submission before this court today that the matters that lay before this court, specifically under Issue 2, contains both matters of Article 41 rights as well as Article 47 rights. Your Honor, Article 41 contains matters of labor relations which are normally addressed in the Employment and Labor Relations Court. However, Your Honor, this matter, specifically issue 2, goes beyond Article 41 rights. We shall rely on the case of Solo Nzuki versus the Salaries and Remuneration Commission, where the court in that matter clearly stated that where matters fall outside the ambit of Article 41 or extend outside the ambit of Article 41, then the High Court has jurisdiction on that particular matter. It is therefore a submission that this court has jurisdiction.
Thank you. Proceed.
Yes, Your Honor.
May I proceed? I'd like to direct you to paragraph 24 of your fact pattern. It seems that the Workers' Union Internal Struggle is pursuing this matter alleging violations of the labor rights in the Employment and Labor Court. Why should this court make a determination while that case is pending?
Your Honor, indeed, there is a proceeding a proceeding that was instituted by the Internal Struggle Health Workers Union in court. However, Your Honor, it is our submission that this situation, or rather scenario, does not amount to sub judice. Your Honor, we shall rely on the case of FIDA Kenya versus the Kenya National Union of Nurses and 4 others, where the court in that matter clearly outlined what amounts to sub judice. That 1, the causes of action must be similar, 2, the parties must be similar, and that 3, one proceeding should be able to completely exhaust the causes of action, or rather the matters sought in the other proceeding. Your Honor, before us today is a matter instituted by Nauru Human Rights Commission. However, in the other matter, it is the Internal Struggle Health Workers Union that instituted that proceeding. Those are different parties, Your Honor. Secondly, the matters addressed in issue 2 are both of Article 41 rights as well as Article 47 rights. However, on the other side, Your Honor, they're solely on Article 41 rights. And finally, Your Honor, this case instituted by Nauru Human Rights Commission also addresses matters of the right to health. However, on the other side, it does not address matters to the right to health. Therefore, Your Honor, this scenario does not amount to sub judice, and therefore all matters are admissible before the court today.
Thank you, Counsel.
Thank you, Your Honor. Without further ado, I shall proceed to the first substantive issue. The petitioners submit that the respondent denied, infringed, and violated the rights to the highest attainable standard of health and emergency medical treatment of the citizens of Tuna Struggle. Your Honor, these rights are founded under Article 41 of the Constitution, as well as the Health Act, specifically under Sections 5 and 7. Article 21 of the Constitution, read together with Section 4 of the Health Act, obligates the state to respect, protect. Your Honor, these obligations were reiterated in the case of Luso Njagi N21 versus the Ministry of Health and 3. In the present matter before this court, the respondents failed to supply hospitals with equipment and medicines. They further allowed prolonged closure of hospitals in the midst of a pandemic. Your Honor, in as much as the respondents launched a National Health Program policy in 2018, they have failed to implement it to date. This, Your Honor, is a total disregard of the obligation to fulfill these rights. Your Honor, we shall... Yes, Your Honor.
Allow me to interrupt you. Is the submission, I've had your submission in relation to the right to health, but my question is the right to health a limited right? And in view of that, what would be your comment in relation to Article 21 to that the state is only obligated to do this progressively?
Your Honor, this right can be limited. However, Your Honor, it must be limited within the ambit of Article 24 of the Constitution, as well as Article 21 of the Constitution. Your Honor, however, in this matter before this court, the rights were limited outside the provisions of this very, outside the requirements of this very provisions, Your Honor. The action taken by the state to suspend healthcare workers was a retrogressive step. This, Your Honor, is not reasonable and justifiable as regards Article 24 of the Constitution. Further, Your Honor, on progressive realization, the state must show that it is taking steps, and secondly, it must use all available resources to progressively realize this right. And thirdly, Your Honor, it should not take any retrogressive step. The state, in this case, however, has failed to do so through the suspension of healthcare workers.
Thank you. Please proceed.
Thank you, Your Honor. On to the second obligation, which is the obligation to respect. It requires the state to refrain from interfering with these rights. Your Honor, as I have just mentioned a few minutes ago, the state of Tunastrago suspended healthcare workers, which led to understaffed hospitals, impairing healthcare service delivery. This, Your Honor, was the total disregard of the right to the obligation to respect. Your Honor, the respondents may choose to argue that they suspended a handful of nurses and other nurses remained in service. However, Your Honor, in reliance with the case of JOO versus the Attorney General, where the court in that matter clearly stated that nurses may be, or rather health workers or nurses may be in service, but fail to adequately deliver the services to the citizens. Your Honor, this case involves a pregnant woman who went to hospital. In as much as there were nurses in the hospital, they failed to deliver their services. The court in that matter therefore stated that the rights to the highest attainable standard of health of this lady were not met. On to the third obligation, Your Honor, the obligation to protect. It requires the state to set up policies to ensure that there is non-interference of these rights by third parties. Your Honor, the respondents in this matter failed to meet this obligation by failing to impose travel and trade restrictions to curb the spread of COVID-19 from high-risk countries. Your Honor, the respondents may choose to argue that they did not impose the travel and trade restrictions because of the income they get from tourists from outside the country. However, Your Honor, it is our submission before this court that pursuant to the fact sheet, the 23% of the tourists that came to Tunastrago were from Chinku. Chinku is the area of origin of this disease known as COVID-19. And further, Your Honor, it is clearly explained that this disease has a reproduction rate of 1.2 to 1.4, a very high reproduction rate. Therefore, Your Honor, their failure to impose travel and trade restrictions to curb the spread of COVID-19 was a total disregard of their obligation to protect. Having proven the above,
Counsel, just a moment. Are you telling this court that the state of Tunastrago did nothing to curb the spread of COVID-19? Is the standard measure only restricting travel in and out of the state?
No. The state of Tunastrago was able to put in measures such as the wearing of masks, banning social gatherings. However, Your Honor, it is our submission before this court that it was fundamental that they put in place travel and trade restrictions because of the number of tourists that flood into the country, and because specifically these tourists are from the country of origin of COVID-19. It was therefore mandatory and fundamental that they put in place such a restriction, and owing to the fact that many countries worldwide were taking such measures.
Thank you, Counsel.
Thank you.
Thank you. You have about 3 minutes to go.
Thank you, Your Honor. With permission from the bench, I shall proceed to the second issue. The respondents submit that the suspension of the healthcare workers was a violation of their right to work, industrial action, and their right to fair administrative action. I shall tackle these violations in 3 limbs. 1, the right to industrial action. 2, the right to fair administrative action. And 3, the right to work. As regards the first limb, Your Honor, Article 41 of the Constitution guarantees every employee the right to go on strike. This right is further guaranteed under Section 76 of the Labor Relations Act. Your Honor, Article 27 of the Constitution guarantees every individual the free benefit of law, of enjoyment of law, or rather, the protection and benefit of the law. The right to protection and benefit of the law. Your Honor, in the case of Kenya In the case of Moot Teaching and Referral Hospital versus the Kenya National Union of Nurses and 5 others, the court in that matter clearly stated that courts should not read restrictive rules into that courts, Your Honor, that courts should not read restrictive measures, or rather restrictive rules, where attempts to resolve employment issues have hit a brick wall. Your Honor, such a matter is before this court. The Tunastrogo Health Workers Union tried to reach out to the government to solve the disputes that lay between them. However, Your Honor, yes, Your Honor.
Excuse me for interrupting. Can you indicate to us which arm of government suspended the healthcare workers and why they're not party to this? Why they're not party to this case?
Your Honor, the arm of government that suspended the healthcare workers were the county governments. However, Your Honor, they are not party to this suit because pursuant to Article 6 as well as Article 189 of the Constitution, the two levels of government are interlinked and work in mutual cooperation. Therefore, Your Honor, we chose to sue the national government in lieu of the county government because of that matter. We shall also rely on the case of R versus Transitional Society, let me just get that citation, R versus Transition Authority and another, ex parte KMPDU and 2 others, where the court in that matter clearly stated that the fact that health services are devolved does not discharge the national government from its obligations to ensure that its constitutional obligations are fulfilled. Therefore, Your Honor, that is the very reason why we sued the national government in lieu of the county government.
So, Counsel, allow me to ask a follow-up question. Would you want this court to ignore the fact of devolution because the rightful employer isn't before this court, and whether or not the national government has functions with regard to Schedule 4 of the Constitution? The national government functions are limited to policy making as well as tertiary institutions, as well as level 6 institutions. So level 1 to 5 institutions and healthcare workforce are within the ambit of the county government. Additionally, you didn't even include the Council of Governors to this dispute. So would you like us to hold the national government liable for acts by an arm of government that is not itself and ignore the fact of devolution in this country?
No, Your Honor, we are not ignoring the fact of devolution. We shall still rely on the provisions of Article 6 of the Constitution that shows that these two levels of government work in mutual cooperation and that they're interlinked. Therefore, Your Honor, that is our standing on this matter.
Thank you. Just reminding you that your time is up.
Your Honor, I plead for an additional 3 minutes.
Granted, proceed.
Thank you.
Counsel, allow me to interrupt on your borrowed time, though. In relation to the strike, you have given some submissions, but I wanted to ask, were the guidelines given in Section 76 of the Act really followed, noting that there was no written notice that was given to the government before the strike was started?
Indeed, Your Honor, it is our position as the petitioners that the requirements under Section 76 were adequately met. They gave a 3-week notice that they would strike if the respondents would not provide them with equipment and increase their allowances. However, Your Honor, the facts are silent as to whether the facts do not indicate that there was no written notice. Therefore, Your Honor, they went on media, yes, and there may also have been a written notice to the ministers in charge.
Thank you. Please proceed.
Thank you, Your Honor. As regards the second limb, Your Honor, the right to fair administrative action. This right is founded under Article 47 of the Constitution, as well as the provisions of the Fair Administrative Actions Act. Your Honors, Section 41 of the Employment Act clearly states that before an employer takes a disciplinary action against an employee, he must give reasons for it and he must grant that person a fair hearing. Your Honor, we shall rely on the case of Republic versus KMTC, ex parte James Kendagor, where the court in that matter opined that the right to a fair hearing has 2 key facets. That one, the person must be informed of the charge against them, and that two, he must be given an opportunity to be heard. Your Honor, in the present matter before this court, the health workers were not informed of the charge against them, neither were they given an opportunity to be heard, nor were they given written reasons for their suspension. This was a total disregard of their right to fair administrative action. As regards the third, yes, Your Honor.
I'd like to know whether they are essential service providers, or do health workers have a right to strike? Okay.
Your Honor, indeed, the health workers are essential service providers. This is pursuant to the 4th schedule of the Labor Relations Act, which clearly states that hospital services, or rather services under the hospital that fall within the confines of the hospital, are essential services. However, Your Honor, pursuant to the case, or rather in reliance of the case of Okia Umtata versus the Attorney General and 5 others, where the court in that matter clearly stated that the provisions of Section 78, as well as Section 81 of the Labor Relations Act, are in conflict with the Constitution. This is because they limit the right to strike of essential service providers illegally. Your Honor, the essential service providers require a recourse whenever there is a trade, or rather whenever there is a dispute. However, Your Honor, these provisions disregard the opportunity to be heard or to address the matters that affect them. As regards to the final limb of arguments, which is the right to work, it is our submission before this court that the suspension of the healthcare workers was a violation of their right to work, because the suspension of the healthcare workers was a violation of their right to work, because they were suspended without due procedure, without being given a fair hearing, and without being given written reasons for their suspension.
Thank you, Counsel. Your time is up.
Thank you, Your Honors. I shall therefore invite my co-counsel to address the court on the 3rd and 4th issues, as well as our prayers. Thank you.
As earlier on introduced, my name is Luis Morara, and undertaking the remaining time to handle the 3rd and 4th issue, as well as the prayers. It is with the court's permission that I would like to proceed.
Proceed.
Your Honors, in the words of Malcolm X, even if you assassinate Martin Luther, even if you crucify Jesus, and even if you poison Socrates, the issue at hand still remains. We are here today to stand in solidarity of the families of the deceased persons, as well as the 2 missing persons, and as well as the citizens of Transstruggle at large. That this is a passing cloud, and the pandemic will come to an end. Your Honors, with regards to the 3rd issue, the petitioner submits that the enforced disappearances and extrajudicial killings of the 4 people is a breach of the Constitution of Transstruggle and all relevant international instruments. Your Honors, with regards to the 3rd issue, the petitioner submits that the enforced disappearances and extrajudicial killings of the 4 people is a breach of the Constitution of Transstruggle and all relevant international instruments. Your Honors, Article 26, 27, and 29 of the Constitution, read together with Article 6 and 9 of the ICCPR, guarantee the right to life, the right to freedom and security of persons, as well as the right not to be subjected to degrading, cruel, and inhumane manner. Further, Your Honors, Article 21 places general duties upon the state to ensure that those afforded these rights enjoy the said rights. As was in the case of Republic versus the Commissioner of Police ex parte Phyllis Damoy, where the court held that the state has a clear-cut responsibility of ensuring that it provides security for its citizens. Your Honors, in as much as 4 people could go missing after attending a meeting called for by the government at ministerial offices, indicates the failure on part of the state to ensure that there was indeed provision of adequate security to its citizens. And
sorry, I'll just have to cut you short right there. Could you kindly guide this court by defining essentially what it is when we say that there is enforced disappearance? Let's start from there.
Thank you, Your Honor. Enforced disappearances, as defined in the International Convention protecting all persons against enforced disappearances and Article 2, and was as reaffirmed in the case of the last case, Rodriguez versus Honduras, it was held that in order for there to be enforced disappearances, there has to be 1, acts of deprivation of liberty, and two, that these acts are indeed attributable to the state, and thirdly, that the state has denied these acts.
Thank you so much, Council. So you've picked, you've mentioned a co-ingredient in terms of addressing matters of enforced disappearance. So I'll take you back to your last submission where you indicated that 4 persons went to a ministerial meeting and they went missing. How do you link that with the requirement in the definition of enforced disappearance to prove that indeed it is the state that made these things happen in terms of the disappearance?
With regards to attributing the said abductions into the case of the missing persons, we rely on circumstantial evidence, as the circumstantial evidence points out to the state being the perpetrators of these acts, in that Nina and Mason were harsh critics of the state. And as was affirmed in the case of Rex versus Arab-Koske and another, where it was held that the inculpatory facts have to be incompatible with the innocence of the other party. And in this case, Your Honor, the inculpatory facts point out to the state as being the perpetrators of these acts.
Thank you, Council. Thank you.
Within those 5 minutes, what is this? What are these facts that you're referring to that link the disappearance to the government? The specific facts, if you could just list them.
And Council, as you answer that, my apologies as well for piling on, but as you answer that, can you please indicate to this court, what about the 2 persons who were found? Why are you not just asking the court to pursue a murder? Why are you not just going to the police and alleging murder took place or manslaughter?
Your Honor, I will reverse the first question on the facts. From the fact sheet, it is evident that Nina and Mason were harsh critics of the government. And in that, the government invited these persons to the meeting that was called for by the government. And in that, regarding circumstantial evidence, in relation to the fact that these persons were harsh critics of the government could have had a hand in their disappearances to ensure that they were no longer critics of the government. With regards to the second question, why are we not pursuing a murder charge? Your Honor, enforced disappearances infringe on so many rights altogether, including the right, and as I earlier on mentioned, the right to freedom and security of persons, as well as the right to family life and the right to information. I can see I have 3 minutes.
Also, I apologize, but I would like to ask a follow-up question on that. In terms of the convention that you're relying on, can you, one, speak on its nature, whether or not it's binding on the state of Tuna struggle? But secondly, in terms of the convention, does it satisfy the convention if bodies are present? Is it an enforced disappearance once bodies have been found in terms of that convention?
With regards to the convention, it is clear that indeed the state of Tuna struggle has not in any way ratified the said convention, but it is a signatory. And in relation to this, Your Honor, Article 18 of the Vienna Convention on Law of Treaties obligates states to refrain from acts that beat the purpose of treaties. Hence our reliance on the said act. In regards to the 2 deceased persons, Your Honors, in the case of Velasquez Rodriguez versus Honduras, where deceased persons or where there are cases of killings, they cease from becoming enforced disappearances and turn out to become extrajudicial killings.
Council, if you allow me, I also have a follow-up question. Then in relation to these other 2 that are still lost and you don't know where they are right now, why are you not pursuing habeas corpus if you are very confident that they are in custody of the government?
Your Honor, from the facts, it is evident that the circumstantial evidence points out to the state as being perpetrators of these acts. But in lieu of there being no direct evidence, habeas corpus reads upon where there are cases of arrests. And as such, the state has not made any arrest. But indeed, we can concede to the fact that there has been detentions, which are arbitrary as opposed to lawful arrests.
And so beg to just ask a further question, one last one. And I get what my sister, who's a fellow judge hearing, was driving towards. Why have you not pursued a habeas corpus? Because there are components of habeas corpus that would prove to this court that indeed the 4 persons who have disappeared were essentially either in legal custody or there is a direct link to their deaths or disappearance to the state. So can you confirm to this court that they were in legal custody? And if you can, please give us either an OB number or something that we can refer to.
Your Honor, as I had earlier on alluded to, we are not relying on rates of habeas corpus because, as I have mentioned, there were no arrests that have been made, but we are relying on the distinctive test with regards to the first criteria in relation to enforced disappearances, where there has to be not only arrests, but there has to be detentions or deprivations of liberty. In this case, Your Honor, there have been no lawful arrests, but there have been arbitrary detentions as regards the circumstantial evidence pointing out or pointing fingers towards the state.
Thank you, Counsel.
Your Honor, we preempt that the respondents might want to submit that that we have failed in proving in discharging our evidentiary burden of proof. However, Your Honors, we wish to direct this court to the presidential election petition 1 of 2017, the Raila Odinga case, which was held that the standard of proof when it comes to constitutional petition matters is one on a standard of probabilities. Your Honors, I would like to move on to the second issue. And I can see my time is fast moving. I request for additional 3 minutes to sum up the fourth issue as well as the prayers.
As you follow up the fourth issue, I would like you to just briefly address us on the burden of proof as well for purposes of the enforced disappearance. Proceed.
With regards to the burden of proof, Your Honor, Section 1 of the Evidence Act states that he who alleges must prove. And with regards to enforced disappearances, Your Honor, with these acts being mostly perpetrated by states, it is hard to find direct and concrete evidence linking the state as the perpetrators of such acts. Hence, our reliance on circumstantial evidence, and as earlier on pointed in the case of Rex versus Arab Koski and another, it was held that circumstantial evidence indeed is a form of evidence. With regards to the third issue, Your Honors, the petitioner submits that the state of struggle has failed in its constitutional and international obligation with regards to its fight against corruption. Your Honors, Article 227, read together with Section 2 of the Public Procurement and Disposal Act, outline the minimum requirements of transparency, accountability, competitiveness, and cost-effective when it comes to a valid tender process. Further, Your Honors, Article 232, read together with Article 5 of the United Nations Convention Against Corruption, provide that public resources should be used in a prudent, responsible, and efficient manner. Your Honor, this is not the case, as the state of struggle in its tendering process did not in any way involve the public. Further, the tendering process was done in secrecy and outside the confines of law, and as such, it is unconstitutional, as it does not uphold statutory and constitutional provisions as expressed in the Constitution. Further, Your Honor, as was in the case of Kituo Sheria versus the CBK and 6 others, it was held that public participation is a key ingredient when it comes to the procurement process as well as the tendering process. Your Honor, further, Section 40 of the Public Procurement and Disposal Act outlines that there should be abstinence from collusion. This is not the case, Your Honors, as there was inflation with regards to the award of tenders, and further, that these tenders were awarded to personnel within the Ministry of Health, as well as cabinet secretaries. Hence, the state failed in its statutory obligation with regards to abstinence from collusion.
Given that there's an ongoing investigation by the rightful authority around issues of ethics and anti-corruption, why would you want this court to pronounce itself on this while the matter is not yet ripe for determination by judicial body?
Your Honors, as was in the case of Republic versus the IEBC and 3 others, ex parte code, it was held that With regards to pending investigations, the court guided by the ambits of Article 23 of the Constitution, that the court has supervisory jurisdiction when it comes to public entities. And Your Honor, with regards to timing, Your Honor, it has been 2 years, Your Honor. Investigations cannot be still ongoing. Guided by the case of CS versus Romania, where the European Court held that investigations have to be prompt. They have to be prompt, fast, and efficient to ensure that the culprits and perpetrators of such acts are nabbed and brought to book.
Counsel, would you like this court to determine a specific standard for how long investigation should take? Would that be not us going beyond our mandate as a judicial body and going into issues of the executive?
Indeed, Your Honor, we do not wish these courts make a declaration as to the timings with the investigation. We submit that with regards to the case of CS versus Romania, that investigations should be prompt, efficient, and fast to ensure that culprits are brought to book, and further, that they are punished.
Thank you, Counsel.
Thank you, Counsel. Your time is about done. So if you could just finalize.
Yes, Your Honor.
Subject to the question by Judge Moroga.
I will wrap up, Counsel. Could you comment on why not go for independent institutions dedicated to fight corruption as opposed to going for a general claim against the entire state? Thank you.
Your Honors, with regards to independent institutions that are tasked and mandated with fighting corruption, Your Honor, it is evident that indeed investigations have begun, but these investigations are taking too long. And in issues of this matter being a public interest, we require that all stakeholders, as these institutions are within the ambits of government, they fall within one of the arms of government, that is the executive, that will call the attention. And as this matter is a public interest, we call the attention of not only these independent institutions, but all stakeholders when it comes to the government. Your Honors, I would like to move on to the prayers. With regards to prayers, we ask that this court finds that indeed the state has violated the right to the highest attainable standard of health and emergency medical treatment. Secondly, that the state has indeed, with regards to the suspension of healthcare workers, the state violated their right to work.
I apologize for the interruption. However, you made no arguments on emergency medical treatment, yet you wanted to make a finding on this.
Your Honor, I believe my co-counsel did make arguments with regards to the emergency medical treatment.
She did not as defined within the Health Act and all other pursuant legislation on emergency medical treatment. She spoke to the duties of the state to protect, to respect, but not on emergency medical treatment, but on the right to health in general. So would you like us to make a finding where you have not made any substantive submissions?
In any case, Your Honor, even if she did not make that submission with regards to emergency medical treatment, it is my submission, Your Honor, that this emergency medical treatment is closely interlinked and related to the provision of the right to the highest attainable standard of health, as is under Article 41.
Thank you, Your Honor. Time is up. Do you have anything else to say?
Maybe just to finalize on my prayers, Your Honor.
We have them in writing, so I think for purposes of looking at them, we'll look at the documents.
Thank you, Your Honor.
Thank you very much. We'll move to the respondents.
May it please this Honorable Court, I shall now begin my submissions. My lords and my ladies, while a court has no jurisdiction, it should burn its tools. The respondent would like to contest the jurisdiction of this Honorable Court based on two things. And to be very specific, we contest the jurisdiction of this Honorable Court on the second issue of merit before it. The first thing under which we contest the jurisdiction of this court is that the Constitution did envision the creation of an Employment and Labor Relations Court under Article 162, Clause 2 of the Constitution. This court was established to deal with issues that deal with employment and labor relations. Furthermore, Article 165, Clause 5 of the Constitution does provide that the High Court shall not have jurisdiction to hear matters that are within the purview of the courts found under Article 162, Clause 2 of the Constitution. My lords and my ladies, you may ask, what is a substantial issue in Issue 2? It is the submission of the respondent. The substantial issue in the second merit before this Honorable Court is to deal with employment and labor relations. In the case of Muhammad Ali Badi and others via Attorney General and 11 others of 2018 before the High Court, and specifically paragraph 105 of the High Court's judgment, it was stated that the test in cases of bonded jurisdiction, such as one before this Honorable Court, the Court must apply the test of what is the substantial issue before it. My lords and my ladies, it is my submission that the substantial issue before this Honorable Court in the second merit before it is employment-labor relations. The second limb under which we contest the jurisdiction of this Honorable Court is that we invite this Court to invoke the principle of this alibi pendants. My lords and my ladies, it must be noted in paragraph 24 of the fact pattern that the Healthcare Workers Union had already filed a case before another court regarding the labor relation rights. My lords and my ladies, may I guide this court the case of Okia Mtata became the Board of Management of 2019 before the High Court, and specifically paragraph 35 of the High Court's finding. It was ruled that where a matter is pending before another court should not rule on it and should shy away from ruling on it because there might be a conflict of jurisprudence. My lords and my ladies, it is our submission that this court should invoke that doctrine. Where a court has no jurisdiction, it should down its tools. These are not my words. These are the words of the learned Justice Nyarangi in the case of the owners of motor vessel Lillian S. Caltex Oil of Kenya, 1989, before the Court of Appeal, a locus classicus case. Therefore, I do urge this court to withhold itself from hearing and determining the second issue made before it. And in the unlikely event that this court does find that it has a requisite jurisdiction to hear and determine the second issue made before it, we submit our arguments as follows. Furthermore, the respondent does not contest the standing of the petitioners in this matter. If there are no questions, and without any more delay, I shall move on to address the first issue of merit before this Honorable Court. It is the submission of the respondent that the government has upheld the right to the highest attainable standard of health and emergency medical treatment of the citizens of Tuna Struggle. The right to the highest attainable standard of health is found under Article 43, Clause 1, Subclause A of the Constitution, and the right to emergency medical treatment is found under Article 43, Clause 2 of the Constitution. It is my submission that since both of these rights are found under Article 43 of the Constitution, they are subject to progressive realization pursuant to Article 21 of the Constitution. We must note the importance of this doctrine of progressive realization of socioeconomic rights. It was adopted as a flexibility device to ensure that developing countries, such as Tuna Struggle, as shown by Fact 1 of the fact sheet, will not be able to ensure the full enjoyment of these rights immediately. My lords and my ladies, the petitioner has belittled the fact that Tuna Struggle is not a developed nation and that its resources are stretched thin. We do recognize that Article 20, Clause 5 of the Constitution does provide that the state must show that it lacks resources in matters when claiming that it can't have enough resources to attain a socioeconomic right. We do recognize this fact. However, we would like to state and emphasize that
So,
the struggle
Mr.
in developing nation.
You referred to an article in the Constitution. Could you kindly repeat that for the benefit of this bench?
My lady, which particular article, what was it to
Article 20, you mentioned Article 20, is it?
Clause 5.
Article 20 of the Constitution of Kenya?
Yes, my lady.
Clause 5. Okay. Please proceed.
As shown by paragraph 31 of the fact, as shown by the fact pattern, my ladies and my lords, the struggle government had tried to go to the International Monetary Fund to ask for funds, since it does lack funds. We do concede that the International Monetary Fund did deny us funds because they said our government was unaccountable. My ladies and my lords, it is my submission that our government will not let a few individuals within it tarnish the good name of Tuna Struggle. It is. Yes, my lady?
Allow me to interrupt you. So you are relying on Article 25, Article A, and your assertion is that you have tried to seek resources to address this. But I would like to address you to the fact that you have healthcare workers who are resources. So looking at what makes up a health system, financial and human resources are both resources. You have healthcare workers who are currently on strike and have been suspended from work, who can no longer be accessed. How do you address that, given that you're not utilizing the resources that you have within the country?
Thank you for that question, my lady. It is a very interesting question. We do recognize that human beings do form part of the resources of the state. However, we'd like to point out that the healthcare workers' strike was illegal and that they were already on strike by the time that the government suspended them. In my submissions to you with the second issue made before this Honorable Court, I shall substantially prove that the healthcare workers' strike was illegal and that is what caused the complete breakdown of the healthcare system of Tuna Struggle.
And I guess a follow-up question on that aspect. Is it a submission that we allow the right to health, in this case, be realized progressively, while under paragraph 32, citizens continue to die every day? How progressive will that be? Thank you.
Thank you for that question, my lord. It is the submission of the respondent that it is taking steps towards progressively realizing the right to the highest attainable standard of health and emergency medical treatment of the citizens of Tuna Struggle. In fact, thank you very much for that question, my lord, because it seems that you have foresight into my next submissions. It is the submission of the respondent that the government has taken steps towards the progressive realization of these two rights. If I may refer this court to Article 2 of the International Convention on Economic, Social and Cultural Rights, it is stated that in progressive realization, a state must take steps, and a state must make sure it's using its maximum available resources. Furthermore, there is a requirement on the state to take non-regressive steps towards the achievement of these two rights. The government has taken steps. In fact, it has taken legislative steps. Paragraph 8 of the fact pattern shows that the government did amend the Health Act 2017 to ensure the protection of the right to health and emergency medical treatment. And the government did introduce the National Health Program under paragraph 9 of the fact sheet to ensure the protection of these two rights. Even during the COVID pandemic, the government instituted the wearing of masks in order to ensure the protection of these rights. My ladies and my lords, it is my regrettable submission that it is the healthcare workers' strike that did occur under paragraph 22 of the fact pattern that did cause a complete breakdown of the healthcare system of Tuna Struggle.
Also, allow me to simply interject and ask. So you are talking of implemented measures in terms of ensuring that the COVID spread has been cut by the government, and you've talked about wearing of masks. would you indicate that that particular measure was implemented as per the applicable international minimums, the applicable standards? And if you have any, please tell me the ones that you aligned yourselves to. Thank you.
Thank you for that question, my lady. It is my submission that the government did rely upon the World Health Organization in order to make these recommendations. My lady, it is shown by paragraph 13 of the fact pattern that the World Health Organization was making temporary recommendations towards the governments. And my lady, our government did follow some of the temporary recommendations it was making.
Temporary recommendations are allowed, all right? But even under the same symbols you are alluding to, every state is supposed to craft responses specifically tailored to take care of their people. A pandemic is a worldwide type of, pandemic. Pandemic covers a whole given area, say the world. So if Kenya is going to take up a recommendation from the WHO, are the same recommendations going to be taken up the same way in Italy? Is that what you're saying?
My lady, we must note that these are temporary recommendations, that they are not binding upon the state, but the state can decide to follow these temporary recommendations. Therefore, this brings me on to my next submission. The government did try to utilize its maximum available resources towards achieving these two rights. But it must be noted, as is evident from paragraph 5 of the fact pattern, Tuna struggle has a history of rampant corruption. Our country has suffered under this scourge of corruption. That is why the Directorate of Criminal Investigations under paragraph 26 of the fact pattern is taking steps towards ensuring that those who are trying to spoil the good name of our government are brought to book, and indeed justice will be done.
2 minutes to go.
My lords and my ladies, as I see that my time is quickly expiring, I ask for an extra 3 minutes to finish my submissions on the second issue.
All right, proceed. Granted.
The law has honored us, may we honor it. It is a submission of the respondent that the government did not violate the right to industrial action of the striking healthcare workers by suspending them. This is since the right to industrial action has been duly limited. The right to industrial action is provided for under Article 41, Subclause D of the Constitution, and this right is not absolute. Therefore, it can be limited, and it is subject to the limitation clause that is Article 24, Clause 3 of the Constitution. My lords and my ladies, there are 3 steps that the government must ensure in order to correctly limit a right: legality, justifiability, and proportionality. With regards to legality, it is my submission that the right to industrial action of the healthcare workers has been duly limited by law. Section 81, Clause 3 of the Employment Act does limit the right of workers in essential services to go on strike. And the first schedule of the same act does define healthcare workers as essential service workers. Therefore, the right has been limited by law. And even if the government had failed on this legality test, there is still the justifiability test. In the case of Union of Civil Servants, the Independent Electoral Boundaries Commission of 2015 before the High Court, and specifically paragraph 46 of the court's ruling, it was noted that in order for the limitation of a right to be justifiable, we must demonstrate that the societal need for limiting this right does outweigh the right of the individual to enjoy this right. And indeed, in this case, there is a societal need to limit the rights of the striking healthcare workers. My lords and my ladies, as shown by paragraph 22 of the fact sheet, people were dying waiting in line at hospitals. This strike led to a complete breakdown of the healthcare system of Tuna struggle. Therefore, it is justifiable for the government to try and limit this right. My ladies and my lords, it must be noted that the petitioner said that the healthcare workers were striking and that they had been suspended. Yes, my lady?
Thanks for interrupting you. But it may seem a bit antithetical for us, for your government to suspend healthcare workers when people are dying, and to then ask this court to find that the fault of the healthcare workers in the suspension was within your hands. Was that the only route available to address the strike? Because you're aware that people were dying, you're aware you needed healthcare workers, and your choice in addressing the strike was suspension despite people dying. So it seems a bit rich to suggest that it's the healthcare workers' fault, yet you took the step to suspend them.
Thank you for that question, my lady. It must be noted that the healthcare workers did give a notice to the government 3 weeks before they did go on strike. However, this notice was not written. Section 76 of the Labour Act does provide that in order for a strike to be taken, the government must first ensure that a written notice has been given. The government in this case is the employer of these healthcare workers. It must be noted also that the healthcare workers had already gone on strike by the time that, and the strike was what caused the complete breakdown of the healthcare system of Tuna Struggle.
Council?
Yes,
again, apologies for interrupting, but it does seem like, given they were already on strike, was the suspension meant to limit their right to strike, which you say they don't have? What was the aim of the suspension for this government?
Yes, my lady. The aim of the suspension was to ensure that it will be a deterrent measure towards the other healthcare workers who are not on strike. It must be noted that the healthcare workers who are striking were those who are suspended. Other healthcare workers were still at work. However, it must also be noted that it was a majority of the healthcare workers that did go on that strike.
Thank you, Council. Your time is up. You can will now listen to your co-counsel.
Thank you, Honorable Judge. I now cede the floor to my co-counsel.
May it please this esteemed court, my name is Glory Kobonyo, co-counsel for the respondent. I shall be submitting on the last two issues. The first being that the government is not involved in the enforced disappearance and extrajudicial killings of the 4 people. And the second, being that the government has fulfilled its international and constitutional obligations with regards to the fight against corruption. If I may, I will proceed to the third issue. Any claim alleging the violations of rights must have a foundation in fact as well as incontestable evidence. In this case of enforced disappearance, as counsel for the petitioner had succinctly put, there are 3 elements, and a core element of all these 3 elements is the involvement of the state. In this case, the state is not involved in this enforced disappearance. Counsel for the petitioner relies on circumstantial evidence to prove these allegations of enforced disappearance. Well, as per the case of Abanga Alia Onyango versus Republic, Criminal Appeal number 32 of 1990, specifically paragraph 14, it is settled law that when a case rests entirely on circumstantial evidence, such as this one, it must satisfy 3 tests. The first being that the circumstances from which this inference of guilt is sought to be done must be cogently and firmly established. The second, that those circumstances should be of a definite tendency unerringly pointing towards the guilt of the accused. And the third, that the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and no one else. In this case, The only circumstantial evidence that the counsel for the petitioner has pointed to is that Mina, Mr. Masong, and the two women were last seen at the government meeting. After this meeting, they boarded a jeep and they were not seen since then. If counsel for the petitioner is alleging this, could he please point us to a number plate that is labeled GT, or that the driver who was driving this vehicle was employed by a state agency? It cannot be proven. In these cases of circumstantial evidence, as was established...
Just a moment.
Yes,
just a moment.
Yes,
You've touched on two key things that the petitioners have been relying on to interlink the disappearance and the deaths to the state. You've spoken of a number plate and the driver. And because you have the data muscle that the petitioner may not have, are you in a position to verify to this court that indeed the number plates were not either from the state or by the state, and that the driver therein was not a state employee or a state officer?
My lady, I will turn you to paragraph 28 and 29 of the fact pattern that show that the investigations are still ongoing. In that case, we are not at liberty to expound on matters of an ongoing investigation. If there are no questions, Thank you, my lady. I shall proceed to point out that in such cases of circumstantial evidence, it must be proved beyond reasonable doubt. And this is found in the Republic versus Ahmad Abul Fatih Muhammad and another of 2019, paragraphs 59 and 60 specifically. Now,
this is a constitutional petition and not a criminal matter. Why are you asking us to shift the burden of proof beyond reasonable doubt? We're not making a case as to the criminality of actions of an individual, but the failure of a state to meet its obligations.
Yes, my lady, thank you for that question. I would refer to the same case that counsel for the petitioner referred to, Raila Amolo Odinga and another versus Independent Electoral Boundaries Commission and 4 others, and Attorney General. This is Presidential Petition number 1 of 2017. I shall specifically point you to paragraph 152, which states, we maintain that where allegations of criminal or quasi-criminal nature are made, it is proof beyond reasonable doubt. Now, as per the Rome Statute, Article 7, enforced disappearances are a crime against humanity, and therefore they fall within this gambit, and the burden of proof would be beyond reasonable doubt. If there are no further questions, I shall proceed.
One more question on that issue. Kindly address us on the view that the burden of proof in enforced disappearance cases shifts to the state.
Thank you, my lord. We recognize that the state carries a burden in proving their innocence in these cases of enforced disappearance. And this is why the investigations are being carried out, specifically to point out the perpetrators of these crimes and to continuously expound this information to the public once it is conclusive. If there are no further questions, I shall proceed. Now that I have established that as per the circumstantial evidence, which has not been proven beyond reasonable doubt, the state is not involved in these cases of enforced disappearance, I shall address the next question that would come to mind. If the state is alleging it is not involved, then they still have a responsibility as per Article 21 of the Constitution to protect these rights. We recognize this obligation, and this is why we are actively investigating these crimes, as per paragraph 28 of the fact pattern. And these investigations have gone fruit after identifying the identities of the two women due to the DNA tests in paragraph 29 of the fact pattern. If I may, I will proceed to the fourth issue after leaving the statement. Without government involvement, it ceases to be an enforced disappearance. And with respect to actions of non-state parties, the state is actively investigating with the view of prosecution. With regards to the fourth issue, we will not allow the actions of few individuals to taint the good name of Tuna Struggle. The state is actively abiding by the directives that have been put in place by the Constitution and the international treaties it is party to. As per Article 5 of the United Nations Convention Against Corruption, which calls for the enacting of preventative anti-corruption legislation, if you would refer to paragraph 5 of the fact pattern, you would see that various laws have been put in place, including the Anti-Corruption and Economic Crimes Act number 3 of 2003. Article 79 of the Constitution and Article 6 of the United Nations Convention Against Corruption call for the setting up of an independent body in line with the directives that have been put in place. Now, the government of Tuna Struggle has set up the Tuna Struggle Ethics and Anti-Corruption Commission, also known as TEACC. This body, along with the DCI and a parliamentary committee that was set up, are actively investigating these allegations of corruption. I shall rely on the precedents that was set by the Court of Appeal in the Momo Matemu versus Trusted Society of Human Rights Alliance and 5 others case, specifically paragraph 82, where it was established that the court is not the forum to analyze the veracity of allegations. I shall emphasize, the court is not the forum to analyze the veracity of allegations. The role should be left to the designated independent bodies, which are actively investigating these acts of corruption, and we assure you, these individuals, if proven that they have done these acts of corruption, will be brought in front of the seat of judgment. Yes, my lady. Yes, my lady.
What of the allegations by the petitioners that it's been 2 years since these investigations were instituted, and significantly, you are still in the middle of a pandemic, and you are unable to secure more funds from multilateral partners because of accountability challenges? While the court would not like to intervene in policy issues of the executive, we would like an answer as to understanding how much more time should we be expected as a court and as a country to give you to conduct these investigations, and is there actually political will to finalize this, considering the pandemic is still ongoing?
Thank you for that question, my lady. I would turn you to Article 50 of the Constitution, which calls for innocence until proven guilty. Now, as per this...
Counsel, you are stating this is not a criminal trial.
Yes, but these acts of corruption are criminalized, and therefore it would go to or be referred to as a criminal case. Now, in these investigations, it's a sensitive matter. First of all, I'll point that out. It's a sensitive matter. And so as to ensure that every person enjoys their rights, we are trying to move as expeditiously as possible, but also as thoroughly as possible to ensure that the guilty parties are brought to this court of law.
So you have 3 minutes.
Thank you, my lord. Now, I would continue with my submissions if there are no further questions.
Council, sorry, I have a follow-up question.
Yes, my
As
lady.
you try to demonstrate before this court that you have done your best as a government, what is your view to the fact that the CS of Health in an interview in a local television station actually stated that there are cartels rooted within the deep state? What would you say about that? Are you really doing your very best as a government in relation to corruption issues?
Thank you, my lady. We recognize that that is a serious matter, a very serious one, in fact. And as per paragraph 26 of the fact pattern, the government also recognizes this, and that is why it is investigating this. And it shall, once the investigations are concluded, we shall bring these people before the court of law, as was earlier established. If there are no further questions, I shall proceed. The petitioners have stated that these investigations have not been fruitful. They are conceding to ask this court to adjudicate on veracity of allegations. Now, in the addition to the prayers raised in paragraph 41 of the written submissions, we submit that the court lacks the requisite jurisdiction to entertain the instant petition. The petitioner's premature petition that was heavily relied on inconclusive evidence to which we have successfully offered counter-arguments. Therefore, the petition cannot continue. It can only suffer one fate, that of dismissal. The respondent rests.
Thank you very much for that. As the petitioners, you can now give your rebuttals, if any.
Thank you, Your Honors. On to our rebuttals. One, the respondents do not submit to the jurisdiction of the court. However, we still insist that this court has jurisdiction pursuant to the case that we mentioned earlier, Solanzuki versus SRC, where the court in that matter clearly stated that the High Court has jurisdiction. Sorry, Your Honor, I see you speaking, but I cannot hear you.
Yes, I needed to indicate that you will have 2 minutes for the rebuttal, so do not exceed the 2 minutes that is allocated to you.
Very well. Thank you, Your Honor. On jurisdiction, we insist that this court has jurisdiction pursuant to the fact that the matters contained under issue 2 go outside the ambits of Article 41, and therefore this court has jurisdiction in reliance of the case of Solanzuki versus SRC. On sub judice, Your Honor, we still insist that the scenario, or rather the two cases, do not amount to sub judice. This is because the requirements as enshrined under the FIDA Kenya case versus the Kenya National Union of Nurses have not been met, and therefore it will not be detrimental to the setting of jurisprudence of the matter. As regards to the matter on retrogressive steps, the respondents mentioned, or rather the respondents submitted, that the state did not take retrogressive steps because the healthcare workers were on strike. However, Your Honor, it is a submission that the suspension of the healthcare workers was a retrogressive step because the respondents had an option to actually address the matters of the healthcare workers and ensure that the respondents ensure that the healthcare workers are back to hospital. As regards to the right to industrial action, Your Honor, it is a submission that Article 27 grants every person the right to protection of the law and benefit of the law. As regards to the statement made by the respondents that the healthcare workers were still at work, we would like to refer the court to paragraph 22 of the fact sheet, where it is clearly stated that there was a complete breakdown of the public healthcare system. Therefore, Your Honor, the healthcare workers who were in hospital were not adequate, did not provide adequate healthcare services. As regards the presidential election petition that they have alluded to, that matter, that the presidential election is different from from enforced disappearance, in the sense that enforced disappearances cover a multitude of rights. Therefore, Your Honor, it is our submission that they're different and that such evidence remains on a balance of probabilities. We shall rely on Apolomboya and 11 others versus the Attorney General and 2 others, where it was clearly stated that enforced disappearances have not been criminalized and that such evidence remains on a balance of probabilities and that they impinge on many constitutional rights altogether, the same being reaffirmed in the Willie Kimani case, Your Honor. Yes, Your Honor.
Your time is up.
Thank you.
Thank you very much for that. Do the respondents have any rebuttal?
Thank you. I will presume it's 2 minutes as well?
Yes, 2 minutes.
Okay. I only have 2 issues to address. First is the issue for striking. Now, in this case, the health workers' strike had led to a complete breakdown of the health system, as my co-counsel had pointed out. And would the counsel for the petitioner then want us to go around the whole country and put the health workers in a bus and make them go to work? The only way we could bring these people back to the table as quickly and expeditiously as possible was to issue the suspension and then bring them back to the table of discussion, as is seen in paragraph 27 of the fact pattern, where the government had reached out to the Health Workers Union Committee so as to find a way to bring these workers back to work, as well as address their needs and the needs of the general population. The second issue that we would like to address is with regard to presidential election petition number 1 of 2017. Counsel for the petitioner seems to forget that election offenses are crimes, and therefore with allegations of a criminal or quasi-criminal basis, the standard of proof is beyond reasonable doubt. The respondent rests.
Thank you very much, Councillor, especially for sticking within the time allocated. And with that, I would like to take this opportunity to thank every participant for the submissions that you've made, which were elaborate, both in written form and in the oral presentations. As we retire, we assure you that we'll consider every material submitted and we will render the verdict at the appropriate time, which will be communicated. So for the participants, you can leave as the judges remain for purposes of deliberation. Thank you.
For the past 8 years, the All Kenyan Moot Court competition has been keen on pushing the conversation on human rights within the Kenyan context. Through conducting various Moot Court competitions centered around human rights issues happening in Kenya, we've been able to engage with various stakeholders and, most importantly, law students from across the various universities countrywide to steer human rights discussions among students. This year will not be any different. Even with the COVID-19 pandemic that has changed what would be the old order to what is the new normal, we will hold our conference and Moot Court competitions to push the conversation around health and corruption, with a key focus on the Article 43 right, its realization, government response to the COVID-19 pandemic, and the malignant cancer of corruption that has over the years crippled the Kenyan healthcare sector. Join us virtually from the 2nd to the 5th of June 2021 as we discuss the theme, Combating Corruption in the Attainment of the Highest Attainable Standard of Health. All are welcome.